Rules Committee to come to order. Good afternoon and welcome. I'm delighted to see we have Exhibit A, the gentleman from Kentucky, Mr. Whitfield, who will be with us today. Mr. Whitfield, as you know, probably you're up here as much or more than any other member of the Energy and Commerce Committee, representing not only your committee but also the gentleman from Michigan, the chairman of the committee. And I tell him day after day, thank you for sending Mr. Whitfield. We're delighted that you're with us. I want to thank the gentleman from Georgia, Mr. Whitfield, yesterday for chairing the committee. I heard it was a whole lot of fun, that he didn't miss me at all while I was back in Texas with our primary. Bobby, how are you? Please come on in and join us. But this afternoon I'm back, and today we're going to consider H.R. 4557, Blocking Regulatory Interference from Closing Kilns Act of 2016. On October the 26th, 2015, the EPA published the final 2015 Brick Act rule. The final rule applies to kilns at brick and structural clay products manufacturing facilities and at certain ceramics manufacturing facilities. Compliance for existing affected sources is required by December 26, 2018, despite ongoing legal challenges to the final rule that are currently pending in the Court of Appeals for District of Columbia. H.R. 4557 ensures that there's adequate time for meaningful judicial review before the owners and operators of brick manufacturing facilities are required to make significant and potentially irreversible decisions regarding capital investments, or even to operate less, or perhaps they would just simply decide to shut down. The brick industry is dominated by small businesses, many of which are family-owned and have been in operation for many years and generations through the life of our great nation. And they are struggling. They're struggling in the current economy. I know well from several brick manufacturers in North Texas. This legislation directly benefits the 7,000 workers employed by the brick industry nationwide and ensures an unnecessary and burdensome restriction is imposed. So what we are here to do today is to try and speak as the legislative body who I believe has the authority and responsibility to do not only what we're doing today, but to send a strong signal not only to the administration but also to the industry to let them know that we believe that raising prices on housing at this time and further regulation is a bad thing for our economy. Certainly want to thank, as I've previously done, Ed Whitfield, the gentleman from Kentucky, for joining us today, as well as the ranking member of that subcommittee, the gentleman Bobby Rush, my dear friend from Illinois. Bobby, I'm delighted that you're here. Gentlemen, thank you both for being here. Without objection, anything you have in writing will be submitted for the record. And obviously, before we start your summary and testimony, I'd like to defer to the gentleman from Colorado, the ranking member, for any opening statement the gentleman chooses to make. The gentleman is recognized.
I know we're expecting our ranking member shortly. We're happy to begin the hearing. We welcome back our triumphant chairman and our other returning members from Texas, and I yield back.
Thank you very much. Gentlemen, as you know, we count on both of you not only to represent your party well and the ideas of your district well, but also to come to us as expert witnesses about the testimony that's before us. And we're delighted that you're here. Mr. Whitfield, I'm sure that the opportunity for you to be here today is one that will allow many people in the industry to understand that there are people in Congress who have heard them, and that's why we're here today. The gentleman's recognized.
Well, Mr. Chairman, thank you very much. I'm delighted to be here at the Rules Committee. We appreciate this opportunity to talk about H.R. 4557. I also would like to extend my congratulations to the members who had primaries yesterday and were successful in that effort. We're delighted that you'll be coming back. Mr. Chairman, you touched on the substantive part of this legislation. I will tell you that as members, all of us received a lot of inquiry and asked for support from the brick manufacturers, the ceramic and the kiln industry. I might say that there are 70 of these facilities around the country, and they employ about 7,000 people. And when the EPA came out with this new regulation relating to the hazardous material, air pollutants, we heard from them. They were quite aggressive in asking us for help because that regulation must be complied with, as you stated, by September 2018. Now, this particular industry already has had a lot of experience with the EPA because the EPA finalized a rule on hazardous air pollutants for this industry in 2003. And when that happened, they recognized, as you said, these are small business people, the amount of money that was going to have to be spent to comply for really minimal benefits. And when they kept talking to EPA, asking EPA to work with them, and EPA didn't, other groups also filed a lawsuit. And so the compliance date was 2006. And by the way, they did comply. They spent a lot of money, and they had a 96% reduction toward the goal that was set. But the very next year, the federal court invalidated the entire regulation. And so here we are just a few years later, and EPA is coming back with another rule. And so this industry went and sat down with EPA, asked them for help, explained what had happened the last time, and EPA has not been responsive. So 4 lawsuits have been filed. And all this legislation does, and it's what we see happening more and more, is EPA is betting that compliance must be met with before legal decisions can be made. Utility Act was an example. The Clean Energy Plan just stayed by the Supreme Court was an example. What happened in the BRIC Act was another example. So in this legislation, we just say to the 70 manufacturers, the 7,000 employees, we're not going to try to reverse the rule. We're not going to try to change the rule, the regulation, but we are going to simply ask, don't do anything. Don't enforce this until the federal court has rendered a decision. And I think it's a common sense piece of legislation to maximize the opportunity to protect jobs and protect this industry at a time when we need to be mindful of jobs. And with that, that's what it's all about.
Thank you very much, Mr. Whitfield. Mr. Rush, we're delighted that you're here, Bobby. You're now recognized. Yes, sir.
Mr. Chairman, I also want to extend my congratulations to you and also to the other members of the Texas delegation.
Yes, sir. Mike Burgess, among others,
Yes,
just for
sir.
stunning victory.
Yes, sir. I saw Mike walking down the halls earlier.
See that big smile on his face?
Yeah, and I didn't recognize him because he had his hair trimmed.
Yes.
And so I figured that something must have happened.
Air.
So he had a primary. So he looked good, looked very youthful, and looked good with his hair trimmed like that. So, Mr. Chairman, Ranking Member Slaughter, and members of this Committee on Rules, I'm here to testify on the rule for consideration of the BRIC Act. Mr. Chairman, simply stated, I request an open rule for consideration of H.R. 4557. While I do not expect that there will be many amendments offered to the legislation, I firmly believe that members should have an opportunity to offer amendments that they may have for consideration. Mr. Chairman, H.R. 4557, in my opinion, is an unnecessary bill. The brick and clay maximum achievable control technology, the MAC regulations that are the subject of this legislation are the subject of ongoing legal actions by industry and by the Public Health Committee. Earlier this very week, the industry asked the court to delay consideration of 4 pending suits until the administrator of the EPA responds to a request to reconsider this rule. I understand, Mr. Chairman, the combination of the change in the economic climate for the brick and clay industry and the history of this rule are frustrating for the industry and to the authors of this legislation. And while I believe that there are special circumstances in this instance, I also believe that the Clean Air Act provides sufficient tools to address these circumstances. H.R. 4557, Mr. Chairman, will delay the implementation of this rule until all legal challenges to the rule are resolved by the court. It will delay any subsequent rule issued that is similar in scope and objective until any legal challenges to it were completed as well. In other words, Mr. Chairman, members of this committee, this bill offers an opportunity for endless lawsuits on the issue, and I fear, particularly, Mr. Chairman, that if H.R. 4547 were to become law, we will end up in a situation where we will never control air pollutant emissions from these facilities, no matter how cost-effective or necessary that rule might be. H.R. 4557 establishes a bad precedent that public health protections should not move forward until all legal actions have been completed. We cannot agree to setting this precedent and establishing a process that would delay important public health protections and encourage frivolous legal challenges to clean air rules. The brick, clay, and tile industries would be better served by pursuing the options available to them under the Clean Air Act. The administrator may yet decide to grant their request to reconsider the rule, and if not, they can ask the court to stay the rule. So, Mr. Chairman, I want to thank you for your consideration, and I want to thank all the members of this Rules Committee for their consideration and to the attention that you have given to our request for an open rule. And with that, I yield back the balance of my time.
Mr. Rush, thank you very much. Are either of you lawyers?
I am not. Good. Thank God.
I am, but I don't practice.
Okay. All right. Well, I was going to ask a question of whether the Court of Appeals is having a difficult time scheduling and making decisions. I've noted that a couple weeks ago, the Supreme Court heard a brief, without even hearing a brief, overturned a decision that the Court of Appeals had made 5-4 and overruled what the court had done. But I did not know if they were having problems. I think my point back that I'm trying to make is, Mr. Whitfield, I think this is, once again, a balanced piece of legislation. You're saying this is a significant impact to the industry. Why don't we let it go through the entire process and then let the rule work, as opposed to perhaps starting something that could have cataclysmic upon the operations or upon the employment of people and could arbitrarily cause a big problem. Let's just wait till we know their final answer and then move forward. That's the essence of what you're saying?
Well, I certainly agree with you, and I'm not in the brick industry. I'm not in the ceramic kiln business. But those people have talked to us, and they talk with experience because they all underwent the 2003 rule, and they know how much money was spent there. And they've told us that the average manufacturing plant in this industry, brick and ceramic kilns, have 2 kilns, and that they expect in order to meet this rule, $4 million. These are small business people, and as I said, we're not trying to reverse the rule or even change it, but the history of EPA is they've been overturned and they've been issuing stays in the courts, and that's all this legislation does. It says, let's wait until the court renders a decision before these small business people have to spend these dollars, and some of them may shut down.
Yes, I get that one. But you and I are on the same page. I just think it's wise in what you're doing and very, very balanced, Mr. Whitfield.
This is this is a bipartisan bill. We have 2 Democrats on this bill, and we have 2 Republicans on this bill.
And I'm on it too.
You're on it too.
I was contacted by brick people
Okay.
who called me a long time ago. The young guy is recognized.
Thank you, Mr.
The
Chairman.
youthful young guy.
I really have no questions. I just want to thank both valuable members of the Energy and Commerce Committee. I valued the time I was on the Energy Subcommittee with Chairman Whitfield and Chairman Rush in his tenure. I miss you all, but there's other work that I've been called to do on another subcommittee. And as you can see, I spend my free time in the afternoons up here at the Rules Committee, so you can't ask for anything better than that.
Yeah.
Thank you, Mr. Chairman.
Yes, sir. And by the way, congratulations, Mike. Hi, Louise. You know, this has gotten to be a real important thing, winning. It's hard. Got to go defend your product.
Congratulations to all,
thank you.
everybody that won.
Defending the product is hard.
Yeah.
It's good to see. I missed you.
Oh, good.
Long weekend.
Yeah,
Yeah.
yeah. And now, all next week, we'll all be back in the district.
I'm sure you'll miss me even more.
Oh, my, I don't, we'll just have to struggle along here. Listen, I thank both of you for coming this afternoon, especially my fellow Kentuckian. And, of course, Bobby's been such a good friend. I've been given to understand that there hasn't been any complaint about this regulation, that the industry has not complained. So I'd like to ask unanimous consent to put the statement
Without
of the
objection.
administration policy and to quote it a little bit. This bill apparently was first passed in 1970, amended in 1977 and 1990, each time with broad bipartisan support. The Clean Air Act has improved the nation's air quality and protected public health. And over the same period of time, the economy has grown over 200%, while emissions of key pollutants have decreased nearly 70%. And 45 years of clean air regulation have shown that a strong economy and strong environmental and public health protection go hand in hand. And the Clean Air Act did require the Environmental Protection Agency to finalize all the pollution standards for toxic air pollution from all industrial sectors by 2000. So everybody else has apparently been complying to limit their emissions of cancer-causing toxic air pollutions. Because it threatens the health of Americans by allowing more toxic air pollution, if H.R. 4557 were presented to the president, his senior advisors would recommend that he veto the bill. Put it here for you. That's okay, I'll just leave it here for you. I yield back.
Yes, ma'am. Thank you very much. Mr. Byrne, congratulations. Yes, sir. The gentleman from Massachusetts.
Not a bit.
Oh,
Stunned up.
he put Rebecca out there. That's right. Selfless thing you did, but.
There was a commercial in my race about rules.
Yes, we were, we were.
Was I in it?
Saying, what are those people doing up there?
Well, congratulations
Giving all
to
these
both of
bills
you.
that never go anyplace? Is that, was that
Well, I-
what it was about?
Well, I appreciate you being here. I associate myself with the remarks of our ranking member, and I yield back my time.
Thank you very much, Jim. Gentleman from Colorado, Mr. Polis.
I will be managing the rule tomorrow, and I'm judiciously studying about brick kilns, so I have an hour's worth of material, and I look forward to debating it tomorrow, and I yield back.
Good, thank you very much. Gentlemen, we really do appreciate you and recognize the amount of work that both of you do, along with the gentleman, Mr. Burgess, in this Energy and Commerce Committee. It is amazing the issues that you get into. I may hear about some of them as they come and go, but each of you get into the lifeblood of these issues, and I really respect and appreciate both of you. While you're very dear friends of mine, I know you're very busy and studious in nature because of literally what this committee does. But I want to thank you for taking time to be with us today. If you see Connie, tell her I said hi.
Thank you.
Great, thank you very much.
Thank you so much.
If you gentlemen will please leave anything you had in writing for our awesome stenographer, we appreciate that.
Thank you.
The chairman would now advise the committee that we're open for any other testimony from members, HR 4557, and I see no member that is appearing to give testimony. This now closes the hearing portion of HR 4557, and the chairman will now be in receipt of a motion from the gentleman from Georgia who we spoke of just a minute ago most genuinely, and thank you for handling the committee hearing for me earlier in the week in my absence.
Mr. Chairman, I told folks that they needed to get a real bar to understand what the talent is that we have in that chair on a day in and day out basis. And Louise helped me to demonstrate that to folks, and I appreciate it.
You know what, Louise Slaughter's pretty cool. She's pretty, has she brought you any pies or cakes yet?
I thought that yesterday might have been the day. If she just wanted to poke you with a little stick, she'd have brought the pie out for the day that you weren't going to be here. We were going to be together. But she said she loves you too much to do that to you. It's not going to happen.
You know what? I owe her a Texas pecan pie. So I'm going to bring Louise. I ask about your stuff all the time. I'm going to bring you a good Texas pecan pie next week, 2 weeks.
Cup of coffee, we'll all be happy.
We're all going to be happy. We'll do that. Thank you very much. The gentleman's recognized.
Mr. Chairman, in the absence of any germane amendments being offered, I move the committee grant H.R. 4557, the Blocking Regulatory Interference from Closing Kilns Act of 2016, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of the bill. The rule provides that the bills shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. Section 2 of the rule provides that on any legislative day during the period from March 4th, 2016 through March 11th, 2016, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Finally, Section 3 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 2.
Thank you very much. You've now heard the motion from the gentleman from Georgia. Is there amendment or discussion?
Yes, sir, Mr.
Gentlewoman's
Chairman. I
recognized.
have an amendment
Yes,
to the
ma'am.
rule. I move the committee grant H.R. 4557 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. You've now heard the motion from the gentlewoman. Is there further discussion? Seeing none, the vote will now be on the Slaughter Amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
We
Those
better
have it.
have
Those have.
roll call.
Gentlewoman asked for a roll call vote.
Ms. Fox, Mr. Cole, Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers, Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Byrne, no. Mr. Newhouse. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern. Aye. Mr. McGovern, aye. Mr. Hastings. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 5 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion? Seeing none, the vote will now be on the motion from the gentleman from Georgia. Those in favor signify by saying aye. Those opposed, no.
No.
The ayes have it. The ayes have it. Accordingly,
call, please.
Gentlewoman asked for a roll call vote.
Ms. Fox, Mr. Cole, Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Stivers, Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern. No. Mr. McGovern, no. Mr. Hastings. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
5 yeas, 3 nays.
The The motion is agreed to. And gentlemen, accordingly, the gentleman from Alabama, Mr. Bradley Byrne, will be handling this for Republicans.
As Mr. Polis said, he will be doing a fine learned job on us.
Mr. Polis, who's on the job training.
He's
is gonna
studying,
be-
he said.
Yes,
Studying
on the job training, we'll be handling this for Democrats. Is there further business that we need to handle, knowing that I anticipate that we will not be having another meeting this week, and we further, as you saw in instructions, will be providing instructions for us to take our week where we're back in the district work period. So that will be in the rule also. So
All right.
I'm going to miss you. I promise
Yeah.
to bring some.
I look forward to that. I do love a good pecan pie. That is good.
Thank you very much.